Welcome to Behind the Book, brought to you by the American Immigration Lawyers Association. This program takes you behind the scenes of AILA's best-selling publications. In this edition of Behind the Book, Mary Kramer, author of Immigration Consequences of Criminal Activity, now in its 5th edition, discusses how her book offers a step-by-step guide to representing immigrants in criminal court, from fashioning a plea to post-conviction relief to the significance of Padilla v. Kentucky. Join us as we go behind the book with Mary Kramer. Mary Kramer is one of the leading authorities on criminal immigration issues. She has been in private practice for 22 years and is a solo practitioner in Miami. Her practice is limited to immigration law with a concentration on cases involving individuals with criminal records. Additionally, Ms. Kramer works with criminal lawyers on their pending criminal cases and cooperating witness work. How did you come to specialize in criminal immigration law?
It's a good question. I think that criminal immigration law is very interesting. It involves research, writing, a lot of client contact. You move around. You don't stay in your office. You go to the detention center, you go to the immigration court, you might be going over to CIS. So it's an active, interesting, challenging practice. I started out my practice doing a little bit of everything, thinking I have to do this type of application, I have to do an E, I have to do an L. Can't I find a Cuban baseball player here in Miami? But with time, I realized that what I found to be the most interesting was the criminal immigration work, and I still feel that way, more so.
What do you find to be the most rewarding and frustrating about this area of practice?
Obviously, the rewarding aspect of this type of practice is when you start out with a very complicated case. And a client sits in your office and says, I've been everywhere. I've talked to 15 attorneys. You are my last stop. I didn't want to come, but my friend said, go and see Mary Kramer. And I look at the case and I think too, wow, this is impossible. But I kind of come up with different ideas. And I like sort of the layered strategy, the layered approach. We're not going to throw one dart. We're going to pick up a bunch of darts, we're going to throw them all, and hopefully one will stick. So we're going to work on maybe a little bit of post-conviction relief. We're going to argue it wasn't an admission. We're going to start preparing applications for relief. First things first, we're going to get you a driver's license. Then we're going to see if this application is going to qualify you for a work permit. And then we're going to move forward from there. And then at the end of the day, Tasha, 1 year later, 2 years later, maybe 3 years later, that client is bringing you, I don't know, a box of chocolates, some flowers, giving you a hug because he's a permanent resident or he's been able to keep his permanent residency and you've won the case. That's the most rewarding. Obviously, taking a very, very difficult case, a deserving client, and winning the case. The most frustrating is when you win, but you're robbed. You win the case, you take a look at the case, you look at what you've done, and you review it, and you feel like, you know what? I really did win this case, but the immigration judge or the Board of Immigration Appeals came up with the wrong result. I'm working on a case like that now, where we in fact won in front of the immigration judge. Difficult case, fascinating case, lots of motions, arguments, relief, and the immigration judge granted, but the BIA remanded. And now I'm back with the file. It's in a box like this. I call it the Tupperware because it's a plastic box, but it's a huge Tupperware. And I'm going through everything that was done, and I'm learning the case again, and I'm meeting with the client again, and I'm meeting with the expert witness again. But I'm going through it, Tasha, and I'm thinking, shucks, I won that case. I was robbed. And that's frustrating.
What was the impetus for writing a book on criminal immigration law?
I guess you've realized I can't give any short, quick answers. What was the impetus? The primary impetus, I guess, is that primarily with AILA, but with some other groups, I was doing a lot of speaking on this panel, writing an article, maybe a 20-page article, speaking on something else. And I wanted to bring all of it together into one book. So in fact, that book had been written in my head, and I was walking around with it before I ever started typing. And I sat down with Amy Novick, and I said, look, I got this book, and it's clunking around inside my brain. Would you give me a chance? And Randy Auerbach, remember Randy? And they said, yeah. And I'm grateful to them because I was able to pour it out. But basically, I had been writing this, writing that, but never putting the whole thing together from A to Z. And that's what the book did for me. It allowed me to combine and put together all of the experiences from different articles and panels.
You've been speaking to groups of criminal defense attorneys across the country regarding Padilla v. Kentucky. What is the significance of this case as it pertains to the criminal bar and immigrants accused of crimes?
The Supreme Court's decision in Padilla versus Kentucky, for me, is a Picasso. I have Padilla hanging on my wall. Padilla said what I've been saying all along. People don't always listen to me, but I guess they listen to the Supreme Court. That when a defendant in a criminal case is foreign-born, not an American citizen, part and parcel of a criminal attorney's obligation under the Sixth Amendment is to provide immigration advice regarding the consequences of a plea, regarding the potential consequences under the immigration law if you decide to go to trial. That wrapped up into this look, you might be looking at a 10-year sentence. I think the U.S. attorney is going to want $200,000 in restitution. You've got to also say, and by the way, you will become deportable. You will face deportation. So the significance of Padilla versus Kentucky is that the Supreme Court said what Mary Kramer had been saying all along, but I don't think they took it from me. I think they just figured it out. An immigration attorney and a criminal attorney, we have to work together. The criminal attorney has to be aware of immigration consequences as part of the representation of the non-American citizen defendant.
What are some questions and concerns that this vast section of the legal bar brings to your attention?
Good question. I'm an immigration attorney. I'm not a criminal attorney. They're criminal attorneys. They're not immigration attorneys. I have great ideas on how to fashion a plea, what can be done, avoid conspiracy, get the loss below $10,000, don't let the sentence of imprisonment be more than a year. So I'm throwing out all of these ideas like it's easy. And they're saying, you know what, the U.S. Attorney's Office isn't going to drop the 18 U.S.C. Section 371. They want the conspiracy charge. They're not going to want to sever the co-defendants. I'm not going to be able to keep restitution out of the record. So I'm throwing out all of these sort of pie-in-the-sky ideas to avoid immigration consequences, or at least set the person up for a waiver, to be eligible for a waiver. And they're saying, Mary, sounds really good. But the reality is very often it can't be done. So that is sort of the conflict, polite conflict, but that's sort of the polite conflict going on when I teach a panel to criminal defense attorneys. I'm saying, try this, do this, what about that? And they're saying, oh, Mary, it's so hard.
So you're sort of in a catch-22 in a way.
Yes, but I remind them that it can be done. Not always. Sometimes an individual is going to get a sentence of 10 years for major federal racketeering or controlled substance trafficking. And then the best thing that a criminal attorney can do is say, look, don't get your hopes up. There's no doubt you will be deported. And I think that's important too, because it's all about the client understanding the consequences, not misleading the client. But then again, Tasha, I've worked on plenty of cases at the state and federal level where really creative negotiations and plea bargaining, handling the case well, really does result in a great conclusion, criminal and immigration-wise. You can negotiate sometimes to less than 365. You can sort of arrange for a civil payment of any loss, so that loss and restitution is not part of the record. You can plead down possession with intent to sell to possession, or aggravated battery to battery. The reality is there is a lot that can be done, and that's what I remind my criminal defense bar audience. It can be done. I've seen it done. Let's work together.
You often serve as co-counsel or consultant on criminal cases. What advice do you have for someone handling a first criminal immigration case?
Wow, what would it be? On a personal level, I would say don't let that criminal defense attorney boss you around. Because sometimes criminal defense attorneys, they're practicing in front of a jury, whatever the case may be, they think they're all that. And you've got to remind them that from the client's perspective, the immigration attorney is as important or even more so. Because you know what, Tasha? To serve a few months in jail, even a few months in prison, it's bad. But to be deported to maybe some horrible country, to be separated from your family, from your spouse, from your children, that can be worse. That can be worse. So I think on a personal level, I would remind the immigration attorney embarking on this type of criminal immigration team defense to make sure that the criminal attorney respects them, treats them well, communicates with them. It is such a pleasure to work with a good criminal attorney who appreciates the immigration attorney's input, and it can really be a drag to work with a criminal attorney who thinks, he's the important one and you're just a nice little immigration attorney. So, on a personal level, let that criminal defense attorney know you're important, who you are, establish a good working relationship. In terms of the academics of what you're doing, I think the most important thing is to make sure you're seeing all of the documents. Don't let the criminal defense attorney summarize the case for you or summarize the charge for you. You want to see your arrest report or criminal complaint, the indictment or the information. You want to see what's coming from the prosecutor's office in terms of plea proposals. You want to be very, very involved in what's said at that plea hearing. I think it's really, really important to be detail-oriented. I myself, I'm a visual learner. I like to see the documents. Don't tell me what it says. I think it's important also to get the immigration documents. So you want to make sure the criminal attorney knows that you're all about documents. I want to see the passport because I need to see that non-immigrant visa admission. I want to see the resident card. No, don't tell me when he became a resident. I want to see the card, if I can, passport. And then all of the criminal-related documents. So I think it's really, really important to know when you're working on this type of case to lay out all of the information, all of the documents in front of you, and work from a grounds-up perspective.